dash through discrimination cases in about 20 minutes, so apologies if it is a bit of a dash. I'll go as fast as we can. Discrimination cases always cause the most debate at our weekly technical meetings because they're constantly throwing up new points that we have to consider. We have to look at the ramification of those for how we deal with diversity issues in the workplace, but also because they throw up issues which the wider society is grappling with in a changing world, and that makes them very interesting and also changeable and challenging, and that this year has been no exception to that. Before we go through the cases that I've highlighted, I just wanted to do a very quick reminder of some of the principles that we're dealing with, and I appreciate that some of you will be very familiar with these, but it's always worth having a bit of a refresh. So direct discrimination is when you treat somebody less favourably on grounds of a protected characteristic. And that involves making a comparison between people with the characteristic and their treatment and those without and how they've been treated. And generally speaking, it's very difficult to justify direct discrimination, but there are some exceptions to that. And one of the exceptions may be where there is a genuine occupational requirement for somebody to have a particular characteristic to do a job. So, for example, a woman working within a female changing room, or it may be language skills that are required for a certain job, or a particular religion for a particular job within a religious community, for example. Indirect discrimination occurs where you impose a provision, criterial practice, or a PCP, as it's generally known, which applies to everybody equally, but in practice leads to certain groups of people within the workforce and a particular individual who brings a claim being treated less favourably than others. But it is easier to justify indirect discrimination if you can show that the PCP is a proportionate means of achieving a legitimate aim, and we'll see that language come out in some of the cases that we look at. Also, a quick reminder that disability discrimination is a slightly different beast from other forms of discrimination, and we have two different claims which we don't have in other contexts. Firstly, protection against less favourable treatment for something connected to a disability. So it's not the disability itself that's a problem, it's some feature of that. So, for example, if you have a selection criteria for a redundancy exercise which is based around ill health absence, somebody who is disabled may not be able to meet that as well as others, and that may be discrimination arising from the disability. Also, the duty to make reasonable adjustments. I'm sure you're all familiar with that. The positive duty to take steps to remove obstacles a disabled worker or a disabled job applicant may face as a result of their disability. So, on to disability issues now. And I've picked out a few cases that have come up this year which deal with testing employees, because I seem to be having a lot more questions about tests, which indicates to me that tests are being used much more widely, both on recruitment and in relation to promotions. So the three cases that I'm going to cover look at the questions of whether a requirement to pass a test might amount to discrimination. Is it necessary for a claimant who alleges discrimination to show why that test, why that requirement operates in a discriminatory way in order to bring a successful claim? And what steps should employers take to avoid unlawful discrimination when they're using an assessment tool? The first case was Brooks against Government Legal Services. Now, Ms. Brooks had Asperger's syndrome and she applied for a job, and the recruitment process required her to pass an online situational judgment test. And she said, well, because I've got Asperger's, I find that really difficult. Could I please provide short narrative answers instead? GLS refused, she didn't get the job, and she brought claims for indirect discrimination on grounds of a disability, discrimination arising from disability, and also failure to make reasonable adjustments. And she argued that she'd been unlawfully disadvantaged by having to take the test in the multiple choice question format, and allowing her to provide those short narrative answers would have been a reasonable adjustment. GLS said, no, we don't agree with that. You can't show, we don't think, that you are disadvantaged by this particular test, or that people generally who have Asperger's are disadvantaged. But even if you can, the exam was a proportionate means of achieving a legitimate aim. In other words, identifying the best candidates for the particular job that she was applying for. And the EAT agreed with Brooks. They said that the test did put her at a disadvantage. They were satisfied of that. And that whilst they recognised there was a legitimate aim in trying to get the best candidate for the job, it would have been a small modification to allow the answers to be given in a slightly different format. So it did amount to indirect discrimination. They also found that it was a failure to make reasonable adjustments, because what the EAT did was to weigh up the advantages and disadvantages to each of the parties. And they said that the cost, logistics and the difficulties of comparing answers in different formats which arose for GLS were outweighed by the disadvantage to Brooks in not having the opportunity to be successful in her job application. It would have been a reasonable adjustment to allow the short narrative answers. And they also found, it followed from that, that she had been discriminated against for a reason arising from her disability, her inability to pass the test as well as others who didn't have the disability. Schofield against Manchester Airport Group covers similar ground with a slightly different result. So Mr. Schofield had dyslexia, dyspraxia, dyscalculia and dysgraphia. And he was employed as a trainee aviation security officer. And at the end of the 15-day course, he had to take a test. It wasn't competitive, you just had to pass it and you would get through. And there was no time limit on taking the test. He took the test and failed. The second time round, he was offered help in reading and understanding the questions. He wasn't offered help, although he'd asked for it, in writing out the questions, because Manchester Airport Group said, well, we could read your writing, it was legible, and actually there's not so much that you have to write in answer to these tests, so we're not going to allow that for you. He failed again, and he brought discrimination claims in relation to that failure. And he said that different adjustments should have been made for him, and I've listed those on the slide. He should have been given more time to sit the exam, or maybe other candidates should have been given less time. He should have been provided with an amanuensis, someone not only to read the questions but also to write his answers, and he should have been provided with a private room in which to sit the exam. But in this case, his claim failed. It was recognised that Manchester Airport Group was a large employer, and normally the sort of larger the employer, the more resources, the higher the expectation in terms of what an employer should do. But in this case, it was found that Manchester Airport Group had made sufficient adjustments, and it wasn't reasonable to make the other adjustments that were contended for. I think when we discussed this, we thought that was quite a harsh decision. It's not about whether adjustments are sufficient, it's whether you've taken reasonable steps in relation to levelling the playing field, as it were. But also he failed in his claim for discrimination arising from disability. It was less favourable treatment as something arising from his disability, his failure to pass the exam, but actually it was found that it was a proportionate means of achieving that, a legitimate aim. In that particular case, a lot of emphasis around the need to have properly trained security staff, and that was the basis on which his claim failed. So what does this mean for you? Well, obviously just a good reminder that job applicants can also make claims of discrimination. That's sometimes forgotten. Whether adjustments are reasonable is very fact-specific. It will depend on the nature of the case and the employer and the job that's done. I've listed on the slide some of the factors that are taken into account. But it's also very important to identify the business reason, that legitimate aim, for why you're using a test in relation to recruitment exercises, or indeed any exercise, and think very critically about whether it is proportionate to use it. Is there another step that you could take, another approach which might be more proportionate and then therefore easier for you to justify? The third test on testing, third case on testing, was a claim brought by a number of Home Office employees that went all the way up to the Supreme Court. And in that case, they all failed a test for promotion. And as a result of the sort of failures in that test, which was used over quite a long time, the Home Office had a report written on it, and that report said that candidates from black and minority ethnic and older employees found it harder to pass this test, but they couldn't identify why that was. The report said we didn't know why that was, but that was the finding. And so the question that came up in this case was whether the people bringing the claim had to show the reason why the requirement to pass the test, pass the exam, put groups with certain protected characteristics, their age and their ethnicity, at a disadvantage, as well as showing that they had individually failed the test for that reason, as opposed to failing the test because they hadn't swotted up for the test, for example. And again, went all the way to the Supreme Court, but it was found there that the claimants didn't have to show the reason why that particular test operated in an indirectly discriminatory way. The fact was that it did. All that was needed was a link between the requirement to pass the test and the disadvantage suffered by the individuals. And that's quite problematic, isn't it? Because you could have a test that you're using, but you won't know necessarily why it might discriminate. In fact, it might take you some time to get the right data to enable you to ascertain whether, in fact, it discriminates. So I think what the test is telling us in practice is that where we're using this kind of mechanism to help us recruit or promote, we need to be alive to potential discrimination. We need to be monitoring our recruitment tools for potentially discriminatory impact. And if we think there are trends that suggest there is a discriminatory impact, to think about what we can do about that. Should we stop doing the test? Can we make changes if we can see why it is amounting to discrimination? Or can we justify imposing that test because it's a proportionate means of achieving a legitimate aim? And as I said, employers, though, may take some time to identify if the tests that they're using really do have a discriminatory impact, which leaves you exposed to criticism in the meantime. The next set of cases are relating to the sensitive issue around wearing religious symbols. And both these cases were women who wanted to wear a headscarf at work. Now, they were cases from the French and Belgian courts which were referred up to the European Court. And they asked the question in those referrals, does a dress code which requires religious neutrality amount to direct discrimination, or does it amount to indirect discrimination? And could a headscarf ban for customer-facing roles be justified as being based on a genuine occupational requirement? Now, Miss Achbita was employed as a receptionist. She didn't wear her headscarf for the first few years of her employment, and her employer, G4S, had an unwritten policy that nobody in their workforce should show any symbol of religious, political, or philosophical belief. And that policy was enshrined in writing in 2006. And about the same time, Miss Achbita decided that she wanted to wear her headscarf at work, and she was told that she couldn't. She refused to comply with the policy, and she was dismissed. Miss Bougnaoui was a Muslim woman who worked as a design engineer, and when she was recruited, she was told that there may be situations in which she would have to remove her headscarf because some customers may not like it. And following a site visit by a particular customer, there was a complaint raised, and the customer said, I don't want to deal with her if she's wearing a headscarf. She was told that she should remove her headscarf when dealing with that customer, but there wasn't a blanket policy of religious neutrality. She refused to remove her headscarf, and she was dismissed. But on direct discrimination, Miss Achbita failed in that claim because it was held not to be direct discrimination, to have a blanket policy of neutrality, because that affected everybody. But the court said, well, it could amount to indirect discrimination. We'll look at that in a moment. Ms. Bougnaoui's case, however, did demonstrate that there was direct discrimination, because in that case, she had been required to remove a headscarf, not in response to a policy, but in response to a particular complaint about her individually by a particular customer. And the European Court also went on to say that it wasn't a genuine occupational requirement that in a customer-facing role she shouldn't wear a headscarf. And they said The headscarf did not affect the performance of the employee's work, and the employer in this case appeared to be relying purely on commercial interests based on the preference of its clients. Direct discrimination could not be justified on the grounds of financial loss. On indirect discrimination, some findings which have caused a lot of commentary and concern, in fact. So in Achbita, the European Court held that it must be considered a legitimate aim for an employer to uphold a policy of political, philosophical and religious neutrality in customer-facing roles. And this seems to suggest that, contrary to the way we had approached these issues in the courts, certainly in the UK, that it's not necessary to examine whether the policy is in fact necessary to protect the interests of the customers, which suggests that the employer's right to conduct its business trumps the right of the employee to manifest their religious belief. The court also went on to show that it was a proportionate means to achieve the aim of neutrality if that policy was genuinely pursued in a consistent and systematic manner. And again, this suggests that there doesn't seem to be any need to consider evidence of whether the policy is in fact appropriate in relation to the nature of the employer's business or the type of work that the employee does. The Bugnawi decision, on the other hand, disagreed on indirect discrimination, and they said it may be legitimate to have a dress code, but in that case they didn't think that it was proportionate to ban the headscarf in that particular instance. So what does this mean? Confusion all round, I think. It does not very clear at all, is it? You'll remember the case of Awada that was a reference to the European Court of Human Rights. Miss Awada was an employee of British Airways. She wanted to wear a cross. She took the case all the way up to the court. In that case, I think that the approach, whilst it's challenging because it doesn't give us an exact answer of when you can and you can't apply a policy of neutrality, it does seem a more satisfactory conclusion, because what the court did in that case was weigh up the different interests that were at play. It weighed up the importance of pluralism and diversity in society. It looked at Miss Awada's, what it meant to her to wear the religious symbol, and it looked at BA's desire to maintain a certain corporate image. And when it weighed all those things up, it said it felt that it was fair that Miss Awada could wear her religious symbol at work. And so it's a much more nuanced and balanced exercise there. Now, both of these cases will need to be sent back to their courts in France and Belgium to be decided. So we haven't necessarily heard the end of the story in relation to those. But it does remain very uncertain as to how robust you could be if you wanted to impose a policy of religious neutrality. And I think even if you can legally justify a ban on religious dress, it is important as a business to think about the impact that that's going to have. And that there could be differences in different countries within Europe. So we know that in France, the policy of pursuing the secular society, and we've seen reports about people who have been told in public places they mustn't wear a headscarf, which doesn't sit very comfortably, it seems to me, with the way that we might look at things here in the UK. So there will be cultural differences as well, which the courts are grappling with here. The next set of cases are around shared parental pay. And when this right came in, the big question that wasn't answered was the issue of whether you had to pay men who took shared parental leave the same as you paid women who were on maternity leave. Excuse me. And now we've got the first cases coming through. In the Ali case, Mr. Ali's wife was off for a short time after having their first child. But she had postnatal depression, was told that she should go back to work. And so he said, I want to take parental leave, shared parental leave now. And he said that it wasn't fair that he wasn't paid in the same way that a woman at his employer who was on maternity leave would be paid. He recognised that during that 2-week period after the birth, women have a special protection and they shouldn't be allowed back in the workplace. But he said that, in fact, the leave that was taken after that was leave to care for the child. It wasn't leave related to the fact that the woman had been pregnant or had given birth. It was open to parents to choose who takes that leave, and therefore it followed that it was open it should be the case that they were paid in the same way. And Capita said, no, that's not a valid comparison because only female employees give birth are entitled to maternity leave and pay, so they're in a protected separate category. Excuse me. The tribunal in that case, however, found in Mr. Ali's favour. And the key thing that they featured on was that the leave was the nature of the leave. They said that the leave was in place to allow parents to care for children. It wasn't related to the fact that someone had actually given birth or been pregnant. So it was about caring, and that caring role was not an exclusive role to the mother. And which parent took the time off was a choice, and that, as the tribunal said, that choice should be made free of the assumption that a mother is best placed to undertake that role. Contrast that with the decision in Hextall, where the tribunal went the opposite way, and they called this case a bold and ingenious attempt to gain for men the right to payment of a kind of paternity pay at the same rate as maternity pay. Right at the outset, damned by faint praise, and they went on to say the whole analysis was wrong effectively that we see in Ali, because their focus was on the fact that the maternity leave and pay was special treatment afforded to a woman in connection with childbirth and pregnancy. And that special treatment didn't go further than was necessary to protect women because they suffer such inequality as a result of pregnancy and childbirth. So these cases are both being appealed. In fact, the Ali hearing is later this month and the Hextall hearing in January. My best guess is that this might go further up the courts. But my best guess is that the Ali reasoning is likely to prevail ultimately, because the whole purpose of the shared parental pay was that both parents could take time off to care for their children. And if that's the way that sort of society is going, the recognition that both parents have equal responsibility for childcare, then I think that it follows, as Mr. Ali argued, that both should be paid the same. Ill health dismissals, more frustration. Ill health situations cause the most frustration of any of the cases that we all dealt with, I'm sure. And in this case, it is a good illustration of that. It looked at how long an employer is expected to wait until it can fairly and without discriminating dismiss an employee on long-term sick leave, and also how much evidence that the employer has to show of the disruption to the business of the absence of the employee, which is needed to justify the dismissal. And basically, the school got a bit fed up with Miss O'Brien's uncertainty around her return. She was a head of department. She'd been assaulted by a pupil. She took about 9 months off. She tried to come back to work. That didn't work. She had to go off again. And after about 15 months, the school decided that they were going to dismiss her. She'd been quite difficult about providing medical evidence in the process. She appealed that decision, and at the appeal she brought more medical evidence which suggested that she might be fit to return, but not full-time and not immediately. Nonetheless, the panel who were deciding the appeal upheld the decision to dismiss. They said that the medical evidence was uncertain and inconsistent, the chances of her returning were uncertain, and the prognosis was not in fact good. The ET sides with Miss O'Brien and said the aims of the school were legitimate. They wanted the certainty, they wanted to make sure that they had the right cover and knew where they stood, but the decision was disproportionate and therefore discriminatory and also unfair. What the school should have done was bring more evidence into play of the adverse impact of the continued absence on the school, and they should have waited a little longer to see if she could return. The EAT disagreed and said no, the dismissal was proportionate and it was fair, it was reasonable. So it goes up to the Court of Appeal. Now, the Court of Appeal did show some sympathy for the school and said it's very easy for an employee to say, I just need a little bit more time, please, just be patient with me. But they did say that by the time O'Brien had appealed, there was some evidence that she might be fit to return. And what the school should have done was to examine that evidence. It had OH advisors that it had used before. They should have got that expert view on exactly what that medical evidence meant before deciding on whether the appeal should be upheld or not. So what that means is be careful not to give in to your frustrations too early. We recognise that these situations are difficult and take a long time. But it is important to verify evidence with an expert to make sure you're making the right decisions. And it's also very important to produce evidence of the impact on your business to help justify why the dismissal is the appropriate course. In this case, the Court of Appeal said the employer will need to give more particularised evidence of the kinds of difficulty that the absence is causing. Finally, a case which isn't actually a discrimination case, but it touches on nationality, so it's landed in my patch. This was a recent decision by the EAT in the case of Baker and Abellio, and this was a situation of whether you could terminate someone's employment on grounds of illegality for a failure to provide evidence of their right to work in the UK. And if a contract is illegal, then that is a fair reason to dismiss somebody. Mr. Baker was employed by Abellio as a bus driver. He was Jamaican national, but he had the right to live and work in the UK free of restriction. Abellio did an audit and found that he didn't have right to work evidence on his file, so they suspended him without pay, which seems a bit harsh given that they should have asked for it. But and they then said, go and find the evidence and we'll reconsider. He was unable to produce the evidence or didn't produce the evidence for them, and so they dismissed him. They said that your contract is illegal because we haven't got evidence of your right to work. And they didn't seem to dispute that he did in fact have the right to work. It's just that he hadn't produced the documents to demonstrate that. And of course, giving those documents would have provided the statutory excuse that if you find an illegal worker, you, the employer, have taken appropriate steps to try to identify if they are in fact illegal or not. The tribunal found on the side of Abellio and said, yes, this was an illegal contract, it could be terminated. But even if that wasn't right, they had the right to terminate on the grounds of some other substantial reason because they believed that the contract was an illegal contract. But the EAT disagreed with that, certainly on the illegality point, and they said that failing to obtain evidence of the employee's right to live and work in the UK was not a criminal offence. It didn't render the contract illegal, and therefore it shouldn't have been terminated on grounds of illegality. Obtaining that evidence is clearly good practice, because it gives the employer the statutory excuse, but it's not a criminal offence not to have it. But the tribunal did accept that there was some other substantial reason on which the contract could be terminated, namely the employer's reasonable, albeit mistaken, belief that the contract was illegal, which to me sounds a little bit harsh on Mr. Baker. Because they could have checked that position and taken advice. They were a big-size employer, etc., etc. But that, nonetheless, that's where the EAT landed up. I'm not sure whether that's going to be appealed up to a further level. So that is it for the dash through, except that just to carefully consider what that means for us. Think very carefully about the grounds that you give in relation to the reasons for terminating someone's employment. Hedge your bets. If you've got a couple of choices, it's always worth throwing them in so that you can state your position. And often some of the substantial reason is a fallback position if you're not sure whether you really do have other fair grounds for terminating the employment. But take some comfort of the fact that it's not fatal to a defence if the incorrect decision was given at the time of the dismissal, if you subsequently plead it in defence to a claim.
We've got time for a couple of quick questions, if you have any, for Joe or Sasha or for me on what we've spoken about this morning.
Just a very quick one on that last one. How long had he been working for, Mr. Baker?
No, I can't remember, but a number of years. I think it was quite a long time. I can't remember exactly. It wasn't a recent hire, no. And I think that's why they didn't have the documents on there. Yeah. No. I think it's harsh.
Yeah. Yes. One behind and then lady back second.
I just wondered if you had a view on whether the decision in the Manchester airport case would have been different if they didn't have the kind of security issues?
Yeah, I think when we were talking about this case, we also found that was quite a harsh decision. And I think that was a big factor, and that's certainly what the decision relied on, that, you know, the sort of public interest factor, that, you know, and the public confidence that people had passed the test and were properly trained, etc. So it might well be different in a different situation, yeah.
Because those adjustments that you asked for, they seem to be really reasonable.
Yeah, exactly, yeah. I don't think any of them were sort of difficult to provide for him at all. And in fact, they'd gone some way to provide things. They just needed to go a bit further than they had. Also surprising because an employer of those sort of level of resources, I think, you know, generally speaking, the expectation is you do have to really go out of your way, the bigger you are, to provide adjustments. Yeah.
This is a question for Sasha. I just wondered, is the cut-off date, you mentioned it could be any date between, I think, 23rd of June and this last year.
No, they've said that it won't fall before the date that Article 50 was triggered, so 29th of March 2017, and it won't fall after the date that we leave the EU, so 29th of March 2019.
So it could effectively be, you know,
Yeah.
the 29th of March this year.
It could indeed. Yeah.
One last question.
First, you know, we're looking at our recruitment policy.
Yeah.
We're getting applications from people from abroad, say for the Ukraine. What should we be saying to these people? Because they clearly want to come and work in the UK and they need the appropriate paperwork to come. But I'm saying it's not down to us to apply for it for you, because we're in a grey area of time, aren't we?
Well, Ukraine is obviously not in the EU, so, I mean, it's really, as you say, it's down to you. I mean, if you're a licensed sponsor, you can apply, if you're not a licensed sponsor, you'd need to become one, so you would then need to apply for them for a work permit, a certificate of sponsorship to do so. And that is down to you, because if you did want them to come, they would need to have that permission to work before they could join you. So, I mean, if, for example, they have other reasons that allow them to be in the UK, family reason, for example, then what you'd need to do is ask them at the initial interview, or whenever possible, on what basis are you in the UK, and how can you provide us with evidence that you have the ability to work here. Even if you're not a licensed sponsor, you are required to provide evidence to meet the Prevention of Illegal Working regulations, so show that everybody in your organisation has the right to work there.
But aren't they going to ask the question, can you not find someone in the UK to perform that job role?
Yeah, they will ask it. I mean, if you're a licensed sponsor and you want to bring in a new hire to the UK, you have to first of all advertise that position. And that ad has to stay in place for 28 days. You have to meet a number of requirements with regard to the immigration cap, because obviously only a certain number of work permits can be issued per month. So you do need to advertise, and you are required to take on anybody who meets the requirements set out in your ad, if that person's from the EU or the UK, and you are required to take that person on over and above the Ukrainian national that you previously identified. You can only take them on if they really are seen to be the only person, and you really have trawled the European labour pool to make sure that no one else is available to do that job.
So one last question, lady at the back.
I'm not sure who to address this to, but it was about the religious neutrality, the policy on neutrality. I wonder how you advise on those being drafted to take into consideration individuals' human rights position, so the right to follow a religious belief which might entail something that's visible. How do you write that sort of policy?
I think so I'll stand up so you can see. As I said, it is very uncertain. I think personally, I think the AWADA approach, where you balance up the different rights in play, is the favoured approach to get the likely best outcome. But that does entail exercising judgment in a particular situation about where that balance of rights lies, and that makes it quite difficult to draft a policy that says, you know, these are the hard and fast rules. And somebody has to be in a position to make that decision in the particular case. But I think that is the right approach and is likely to be, I mean, we'll see where these cases go, but I think that it's quite surprising the way that the European Court took the decision in Achbita, and I think that sort of more balanced view is to be preferred. So what does that mean for your policy? It means that what you can do in the policy is set out the sort of principles that might be considered and the factors that might be considered. But I think that you should be looking at things on a case-by-case basis, which I know isn't ideal and doesn't give a certainty, but I think that is the right approach.